This is America, and this is the Supreme Court, the seat of judicial power in this country. Its economic and political and social decisions affect every facet of life for all Americans. It's a branch of government Donald Trump has tried to use to his advantage. But the High Court has a way of standing in his way, too. I'll have more on all of that in a few minutes. But first, here's Alex Marquardt in Washington, D.C.
Thank you, Rosalind. 9 unelected justices, lifetime appointments, and an extraordinary Supreme Court term that in many ways has reoriented American life. On the one hand, the court has told this president, Donald Trump, he cannot end birthright citizenship, while also handing him sweeping power over immigration. The court has gutted the Voting Rights Act, literally reshaping how Congress is elected. And it has provoked something remarkable, a president attacking the very justices that he appointed. Now, historically, the relationship between the highest court in the land and the executive branch was one of respect. Presidents would rarely criticize or even praise Supreme Court rulings, really only going as far as this.
The country wants and deserves a Supreme Court that doesn't make the laws, but interprets the laws.
But the past 3 presidents have really broken that model, and they did not mince their words while doing so.
With all due deference to separation of powers, last week the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections.
Today, the Supreme Court of the United States expressly took away a constitutional right from the American people that it had already recognized. They didn't limit it, they simply took it away. That's never been done to a right so important to so many Americans, but they did it. It's a sad day for the court and for the country.
The Supreme Court's ruling on tariffs is deeply disappointing, and I'm ashamed of certain members of the court, absolutely ashamed, for not having the courage to do what's right for our country. I think it's an embarrassment to their families. You want to know the truth.
So where does the Supreme Court's role end and presidential power begin? Al Jazeera's Rosalind Jordan looks at the balance of power in Washington.
Article 3, Section 1 of the U.S. Constitution reads, "The judicial power of the United States shall be vested in one Supreme Court. 9 women and men currently have the final say on the laws affecting some 342 million people, locked in a recurring power struggle with the President and Congress." In 1867, Congress expanded the High Court's mandate to hear prisoners' challenges to arrest, only to reverse course the next year. In 1935, the Supreme Court ruled several parts of President Franklin Roosevelt's New Deal program to address the Great Depression were unconstitutional. 2 years later, Roosevelt fired back at the courts for conservatives, threatening to expand or pack the court's numbers.
We have therefore reached the point as a nation where we must take action to save the Constitution from the court and the court from itself.
Roosevelt's efforts to pack the court with more justices failed. Opponents accused him of trying to become a dictator. But these days, it's pretty rare that a president doesn't get to choose a court nominee who fits his ideological preferences.
This House is honored by your presence.
Indeed, High Court nominees come vetted for their views, and they get teams of advisors from the White House and the Justice Department to guide them through the confirmation process. At first glance, the process may have worked for President Donald Trump, who nominated 3 current justices. This year, the court ruled Trump could fire federal workers, cut foreign aid, and deny asylum or refuge to some immigrants. But it also told Trump he can't get rid of birthright citizenship, he can't impose tariffs, and he can't take over a state's National Guard on a whim. No surprise, Trump is mad.
Justice Roberts doesn't like when I say it, but the judges are really hurting this country. And frankly, the justices, the Supreme Court, has really hurt our country too.
What's unique about Trump's relationship to the Supreme Court is that he's been willing to publicly criticize justices he appointed himself when their rulings didn't go his way. But there was this reminder from Chief Justice John Roberts to a senior government lawyer during April's hearing in the Birthright citizenship case.
No, but of course, we're in a new world now, as Justice Alito pointed out, to where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
Rosalind Jordan, Al Jazeera, Washington.
From congressional maps to campaign finance, a series of major rulings from the Supreme Court is reshaping the battlefield for Republicans and Democrats just months before voters head to the polls for the midterms. Al Jazeera's Heidi Jo Castro explains.
Voting, the bedrock of American democracy. Where and when Americans cast ballots, how candidates finance campaigns, and who are the people they represent. All of that has been shaped by the U.S. Supreme Court's most recent term. Let's start with the basics. The U.S. is divided into 435 congressional districts. Each sends one representative to the U.S. House, and each district contains 500,000 to 1 million people. How the districts are carved up was at the center of a Supreme Court case stemming from Louisiana.
Whose house?
A group of black voters there argued that because a third of the state's population is black, then a third of its congressional districts should be majority black too. That argument resulted in this map, which created a new district won by Cleo Fields in 2024. But a group of non-black voters, along with Louisiana Republicans, argued that race-based redistricting is unconstitutional. The Supreme Court ultimately took their side, allowing Louisiana to revert to an older map that eliminates Fields' district and that may cut Louisiana's black representation in Congress. This was okay, according to the High Court, because the old map isn't intentionally racist. The impact extends far beyond Louisiana, with 10 states now overtly politically gerrymandering. Republicans have the advantage in 16 newly created House districts. Democrats have created 6. At stake, control of Congress in the midterm elections in November, which are becoming the most expensive in U.S. history.
Gutted the Voting Rights Act.
That's thanks in part to another Supreme Court ruling allowing political parties to give unlimited cash to candidates.
And Georgians pay the price.
The Republican National Committee, supported by large corporate donations, has $125 million to spend. The Democratic National Committee, which is more reliant on smaller donors, has $15 million. The imbalance offers Republicans yet another advantage. But still, there's the High Court's ruling on mail-in ballots. States may continue to count ballots postmarked by Election Day, even if they arrive late. Republicans, backed by Trump, had asked the court to end the practice. That's despite Trump voting by mail himself. And that is how the pillars of power interact with one another in Washington. On this side of the street, the Supreme Court issuing 3 consequential rulings that will impact those elected to Congress on this side of the street. And whoever controls Congress will impact the course of Trump's remaining time as president.
The congressman for that Louisiana district that Heidi mentioned is Cleo Fields. He's been a congressman twice, in fact, first elected in the early 90s and then again in the last election in 2024. But both times his district was redrawn, including this year, and it was removed from the congressional map, most recently due to a major Supreme Court ruling. I spoke with the congressman earlier. Congressman, I want to go back to the Supreme Court's landmark ruling in April. Of course, Louisiana's governor has now signed into law your state's new congressional map following that ruling. What does that mean for the voters who were in your district before it was redrawn?
Well, the voters in the 6th congressional district, as we know it today, will be split among 4 different congressional districts. So tomorrow, 4 different members of Congress will be representing them. I've been moving across the district, talking to constituents. It is just unfortunate. Louisiana's minority population is over 33%, and they have just eliminated the district and making it more possible for yet another Republican to be elected to Congress when Democrats will take over Congress next year. But, We've seen bad decisions from the Supreme Court before. We saw it in Plessy v. Ferguson. It was a terrible decision. This voting rights decision is a terrible decision. But we live to fight another day, and people don't need to be, they don't need to be disenchanted about voting. They need to vote more, not less, and they need to continue to participate in their process despite what this terrible Supreme Court has done to voting rights districts all across the country.
Republicans have argued that this new map was drawn on partisanship, which is allowed, it is legal, not on race, which is not allowed. What do you say to that?
I just think it's a bunch of hogwash. I mean, every person who drew these maps, they knew the racial makeup of each one of those districts. And look, and in Louisiana, you should, and in the southern states, you should. What I'm happy about is I'm happy that other states did not follow through. I'm glad that Mississippi stood down. I'm glad that South Carolina stood down. Alabama, they gave the member a fighting chance, but they, felt the need to go forward. Listen, there's nothing wrong with diversity and inclusion. And I think the president, signing one of his first executive orders doing away with diversity, equity, and inclusion, he sent a dog whistle all across this country, including the Supreme Court, that there was something wrong for whatever reason with being diverse. That's not a bad thing. That's a very good thing for our country. But I don't think this decision is having the desired effect that the Republicans and the president wanted. Only Louisiana and Tennessee have changed their voting lines for Congress. Other states have decided not to, and that's a very good thing.
This is not the first time that you have gone through this. You have fought this twice. You won a majority black district back in 1992. That was then erased a few years later. Then you came back more than 30 years later, only to have now your district again redrawn. How do you reconcile that?
I really thought, my heart of hearts, I thought that we'd really gotten beyond that. I have never served a single day in Congress, not one second, quite frankly, and not have a federal lawsuit pending above my head to do away with the district, only because of the color of my skin and the being a majority black district. No one has ever raised the issue of, when the districts were all white, that there was some problem. The districts look the way they look because of politics, not because of race, and it's just unfortunate. But one day, we overcome it, and I tell people, both blacks and whites, all, people in the district don't feel that way. There are a lot of people in this district of all persuasions who feel that there's nothing wrong with the district, but I keep telling people, listen, we can't take this moment and be bitter. We got to take this moment and be better. But the way we get better is by voting. And that's the message that I've been sending to members of my community and members of this state. If you're upset about it, vote about it. And we need to elect a Congress that's more sensitive to the needs and the concerns of all of the people in this country.
Is there a third act for you? Would you run again?
My point from the very beginning, the issue is not whether or not Cleo Fields serves another day in Congress. The real issue is whether or not a person who looks like me have the opportunity to serve in Congress. And thus, that's the whole purpose of these voting rights districts. It is to give people of color an opportunity to elect a candidate of their choice. And will I run again? Never say never, never say forever, but don't know. But we're going to continue to fight to make America, what it should be, and that is a country of inclusion.
Congressman Cleo Fields of Louisiana, thank you so much for joining us today on This is America, and please keep us posted on your plans.
Thank you, sir. Take care.
Take care. Joined now by Kim Whaley, who is a constitutional law professor and a former assistant U.S. attorney, and Thomas Berry, the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. Thomas, Kim, thank you so much for coming in today. Thomas, if I could start with you, the ruling that I was discussing with the congressman there about Louisiana, that was back in April. Essentially, the court was reasoning that the government should not be sorting voters by race. And that sounds like something that I think most people agree with. But of course, the response to that is that minority voters in that district and elsewhere are being disenfranchised. So in your view, what is the most just solution?
Well, this decision was in line with several decisions by the Supreme Court that put in conflict the notion that we have a colorblind constitution versus the notion that race-conscious programs to benefit minority groups that had historically been oppressed or disadvantaged are permissible. So that's essentially the ideological conflict we see on the court. And there's a clear majority now for the colorblind view of the Constitution. I tend to think that that view is correct, that if you look at the original meaning of the 14th Amendment and its Equal Protection Clause passed after the Civil War, that it was anticipated we would have essentially no laws either giving benefits or punishments to people on the basis of race. The court has allowed, in narrow circumstances, programs to remediate specific examples of discrimination. But unless you can show that, just a general program on the basis of race, I think, is too generalized.
Kim, this goes right to the heart of the Voting Rights Act. And following that decision, Justice Elena Kagan wrote that Section 2 was, quote, all but a dead letter. And Section 2, not to get too in the weeds, but that's the part that lets people sue, if I understand correctly, if it dilutes minority power. So in practical terms, if a state redraws a map that wipes out black political representation, what legal recourse is left?
Well, that's really a big question, because there are other parts of the Voting Rights Act that this court has systematically over many years declared unconstitutional. I mean, just so people understand, I think the answer to your question is the Voting Rights Act. Congress has already authorized this action, this redistricting. Lower federal courts struck down a prior map to comply with the Voting Rights Act. So the big question is here, should elected representatives that are tied to the will of the people make these decisions, or justices who are not elected, who are there for life, override the United States Congress in this regard? And I agree with Thomas on this idea of a colorblind constitution being the new way this court looks at the Constitution, and that goes to the affirmative action case. But let's be clear, the 14th Amendment was enacted after the Civil War. It was about remedying systemic race-based discrimination and enslavement based on a certain race, not white people, but people of color. So the idea of a colorblind constitution making anti-discrimination actions unconstitutional flies in the face of history itself.
So in simpler terms, do you think the court is overstepping?
Absolutely, I do.
Thomas, when we look at the docket, particularly towards the end of this term, it was really quite dramatic. You had a lot of cases that were going the way that the president wanted them to. I'm thinking about what's known as the TPS case, asylum, that the court weighed the way that the president wants. But the president lost essentially on birthright citizenship, on tariffs, on mail-in ballots. So to what extent do you think the Supreme Court is being a check on the president as it's supposed to be versus enabling his agenda?
It's a mixed bag. I think this court is very good at being a check when it's a term of statutory interpretation, when it's a question of what amount of power did Congress authorize the executive branch to wield when it passed a specific statute. A couple terms ago, they overruled the so-called Chevron deference doctrine, which gave the executive branch way more leeway in terms of claiming that a statute allows them to wield certain power, even in borderline cases. They similarly have a doctrine called major questions doctrine that came up in the tariffs case, where they're really skeptical when a president is not able to get his preferred policy enacted through Congress. So instead, he tries to go find an old vague law and find authorization in text where Congress really never intended it. This court has been good at blocking presidents from doing that from a separation of powers standpoint. But on issues of foreign policy, on issues of immigration, it's much more deferential. It has, I think a majority of the court thinks that immigration is traditionally more in the purview of the executive branch by itself. They're also very deferential to the TikTok ban law, again, because foreign policy, domestic security were the main justifications for that. So that's why I see a split in terms of why the president is winning some cases about immigration and foreign policy, but losing others about statutory authorization.
And we should remind our audience that there are 6 conservatives on the court, 3 liberals. 3 of those conservatives were nominated by President Donald Trump. Kim, when you look at those rulings, do you think this predominantly conservative court is doing its job in saying no to the president, or are you seeing some kind of erosion?
Absolute erosion and concentration of power in the executive branch. That was not what I think the framers would have intended. And we have to go back to the summer of 2024 when this supposed textualist court that pays attention to the plain language manufactured immunity for presidents, criminal immunity, if they commit crimes using the massive power of the office. That was a game changer. And the other thing I would point to are the multiple, I think over 20 shadow docket emergency rulings in the first year of this presidency, where the court just didn't even ask for a full briefing and oral argument, overruled lower federal court judges on issues relating to the Fourth Amendment, very due process clause, major questions of constitutional law, just rubber stamping it, basically giving Donald Trump what he wanted in advance of any thorough sort of judicial, thoughtful analysis and full articulation of the issues. That is not a balanced court. And then, I take issue with the idea that overruling the Chevron doctrine was somehow a swipe at Donald Trump. We have seen, and we saw it again this term, with the decision that he now can fire anyone except for members of the Federal Reserve at will. This is a belief that the presidency is a monarch-like position, which, of course, anyone who's seen Schoolhouse Rock or Hamilton knows this is about no more kings in America.
I want to highlight the case of birthright citizenship. That was one of the bigger defeats for the president's agenda. The Supreme Court upheld the right to birthright citizenship, but then the Speaker of the House, the Majority Leader, the Speaker of the House, Mike Johnson, said that Congress would pick up that fight against birthright citizenship. Take a listen.
I'm sure the conclusion from this opinion is going to be that you got to amend the Constitution to fix that. I will say I'm very disappointed in that outcome. I think it subjects the country to serious challenges going forward, and we'll have to deal with it as a Congress. We do need to address it. We're looking at all angles. If there's some legislative fix, we'll advance that immediately. If it's a constitutional amendment, as you know, it takes a little more time. But we've got to address this. It really is a serious, serious issue.
So, Thomas, what can Congress do?
Not much, because the court ruled explicitly on constitutional grounds. Justice Kavanaugh would have ruled more narrowly. He would have ruled only on the basis of a statute passed in 1940. If that's how the majority had gone, then Congress could have amended that statute. But because the 14th Amendment guarantees birthright citizenship, a statute that conflicts with that amendment is null and void under the supremacy rule. So Congress could strengthen the borders in ways such that pregnant women are not allowed in the country. That's one thing they could do. But the Supreme Court has laid out that unless you're a child of a diplomat or on an Indian reservation, the Constitution guarantees anyone else born on U.S. soil citizenship no matter what. There are crazy ideas to reclassify immigrants as part of an invading army. That's an old exception. Or call all of them diplomats. That's not going to go anywhere. I don't think those are serious ideas.
I want to ask about the general atmosphere between the executive branch and the Supreme Court. We've seen Donald Trump go after the very justices that he nominated, Neil Gorsuch, Amy Coney Barrett. He said that they have, quote, hurt our country so badly. He said that they should be embarrassed, that their families should be embarrassed. Kim, how much has the decorum been lost when the American president is speaking like this about the Supreme Court? And how much does it matter?
Well, that's one thing that this president does well, is demolish decorum. And those kind of norms, particularly in the legal community and the rule of law, really matter. They hold up the law, not just the black and white terms of a particular constitutional provision. So that's disturbing for the justices. But I should add, for the lower federal court judges, the sort of attacks on them and threats on them are on the rise. And this is really disturbing, and it should be something that bothers every American, because these folks are there really upholding the law for the rest of us, and themselves and their families should not be threatened. And it's coming from the highest levels of the office. And when the justice system starts becoming about winners and losers based on allegiance to a person or to an ideology, we're no longer a democracy. So this is really the heartbeat of what's at stake in this moment.
Thomas, we only have about 30 seconds left, but what does that do to the rule of law and the perception of independence of these courts?
It's vital that the courts be viewed as independent. The framers gave them life tenure and salary protection so that they would have the standing and the courage to strike down actions of the president, strike down acts of Congress, affirm the constitutional rules that we put in place just so that those principles can be permanent, even though temporary majorities might not like them and might not like the restrictions on them. So protecting the safety of the justices, making clear that the threats to them, I think threats to impeach them based on policy decisions also should be out of bounds. President Trump showed up at the Birthright Citizenship oral argument. I was there as well. I saw him glower. But the great thing about life tenure is there's nothing he could do about it.
All right. Much more to discuss. Turnover in the court, whether the court will be have more justices added. But unfortunately, we've got to leave it there. Kim Whaley, constitutional law professor. Thomas Berry, the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. And that is all from the team here in Washington. Handing back to Rosalind Jordan and Al Jazeera's global headquarters in Doha.
Thanks, Alex. That's it for today's edition, but we'll be back with another one tomorrow. We're taking a look at why it's so difficult for so many Americans to be able to afford housing, as well as a look at the solutions to the crisis. That's at 18:30 GMT, 2:30 p.m. Eastern here in the U.S. Have a good one.